So the idea was that patenting, the process of patenting is quite costly. There's a lot of steps. You have an attorney, you need to do a lot of document fees, and uncertainty. There's a lot of uncertainty. You are going to get it, what's the revenue, and everything. So we have people who sit on the hot seat, who take the decisions day in and day out on how to go about patenting itself, to patent or not. To start off with, I could ask Nilesh. So we have two from the technology side, two from pharma. So I'd like to just throw it open and go for it.
So I just like to quote a few experiences of mine during my IP career. When I used to work in a law firm, one day one gentleman dropped in an office, and he told me that he's having a new idea, and what are the provisions wherein I can keep it secret? I said, if you want to keep it secret, then you're going to go for a trade secret. I mean, if you don't even want to disclose it to me, because I'm the one who will be taking forward your new idea for protecting it. So we discussed about various forms of IPR, and then eventually it drilled down to a fact that his invention was relating to a composition of Ayurvedic medicines. So I told him the procedure. This is what is the Indian patent system is. This is what is the US patent system is, and we'll do a patent search for you, and then we'll draft patent specification, and we will file at the patent office. He was least interested in knowing all these things. The last question he as stressfully asked me is, can you give me 100% guarantee that I will get a grant of patent? So I said, I'm sorry, I cannot give you guarantee, because it's all patent examiners take on this, whether he will issue or refuse the patent application or not based on the patent search. So he got little bit disappointed when I refused to give him a guarantee. So that's how happened when grassroots level inventors really worry about their inventions, and they intend to hear this terminology, patents and all, and then they think of, oh, this is not, something which I can bear to spend the cost and filing. So according to me, to patent or not to patent is a perspective and subjective to the each level of organization, be it an academic institute, research institute, small and medium scale enterprises, large corporate, wherein the large legal entity corporate, they have this annual strategy to file the patents, to generate maximum patent portfolio, and be dominant in the market. That might not be the case for a single inventor or a single applicant. So again, it's all perspective. That's what I have observed in my this patent career.
Yeah, please.
Isn't you think our session should be at the first?
I think so.
Yeah, Manish, what do you think? There is some error in the schedule. Well, we started with patent analytics, we started with landscaping. Rohan there talked about circumvention of the patented invention. Prashant, Madhav all discussed about the collaboration for patenting, and now you are asking me whether to patent it or not. Why? So, rightly said, Nilesh, for an individual, when he or she asks, guarantee hai kya boss? Milega kya patent? Ya beech mein hi ruk jayega? But from industry aspects, from monetary aspects, also there are some concerns whether the invention, whatever is done, is really in line. Whether are we going to really monetize on it? Whether are we planning to stop my competitors? And if I want to stop my competitor, do I really file patent or some way out other? So many things are there when you take a decision in terms of to file or not to file a patent. So this is a very critical aspects where I personally believe, guys, this all databases, this all technology really helps me also in taking this decision, because when I search in such good databases, I'll get prior arts and I'll have an understanding. This is all things are existing. When I'll do some research on the landscaping things, I'll have an understanding of the market, how the geography-wise spreading is there and all. That also helps in taking this decision, whether to do patent or not to do. Yeah, that is how I would start.
So my panelist has already discussed on what is a dilemma. So now I'll discuss what could be a dilemma, especially in a pharma space. So usually we every day has three kind of dilemma. One is political. We don't know what government is thinking. Just to give an example, there is an epidemic probably of coronavirus. So if my company develops something which is going to treat it, whether I'll be allowed to have a patent or whether governments will invoke a national emergency and my patent has no value. I don't get anything in return, but I pay everything for filing a patent, for prosecution, for maintaining and everything. Second dilemma that we face is on a research level. There was a discussion on collaboration session also that whether Indian universities are really looking for protecting their thoughts. Now, these students who are doing masters and PhDs will ultimately join the pharma companies. And if they don't have cultivated this thought that whatever I'm doing first needs to be protected, that's the dilemma we have. Because many times an inventor will approach to me saying, look, I've done something and I intend to publish it. They will never come to me saying, I intend to patent it. So that's a dilemma also, because then we need to really understand why they want to publish it and not patent it. And third dilemma is at a management level, because in pharma, especially if you're working on generics, you don't find too much of innovation happening. It's incremental invention which is happening, and that may not really give a good protection. In terms of 505(b)(2) or NDA space, it's very long journey. We file a patent right now, but we are not really sure whether my molecule is going to hit phase 3 and get into a market. So many times I have personally been asked this question. First question that I get is, whatever we are developing, are you sure will hit the market? And I don't have an answer because I'm not the guy who can confirm it. Second question I get is, will whatever protection we are going to get, will that keep everyone off the market for a period of 20 years? Again, that's something I can't say, because even US government allows that at NC-1 at the end of 4th year, challenge the patent and enter the market. Third dilemma I always have is about the money, because patents are costly systems. So in pharma industry, me and my team are never considered as someone who is generating profit, but we are always accused of someone who is eating up a revenue. Because every time I'm approaching a management that, look, we want to file this IP, please grant me so and so amount of sanctions for filing it across, say, India, US, and all the countries. So this is a dilemma wherein we actually need to look as to what are the results, what are the chances that a company may really have an interest, and at the same time, what could be a government policy. And though I'm also advocating in my company that yes, we should file everything as a patent, at some time considering all this, we just need to back down and say, okay, guys, go ahead and just do a publication. Let's be open for someone else to work on it and further develop something. That's my thought.
That's a very good topic actually, whether to patent or not to. So, good afternoon everyone. And taking cue from my previous speaker Ajendu, I would just summarize the practical considerations made in the pharma and chemical R&Ds, whether to patent an invention or not. So the first thing we generally consider is the patentable subject matter or not. So not that always all the subject matters will be patentable in India. Even if it is India, in other states it may be a different issue. Just now I think Christine said that method of treatment patents, the second medical use is not patentable in India, correct, very correct. So similarly, method of treatment patents, not patentable in India, but in the US it is. So one has to consider from that point of view that whether or how shall I draft the claims, if at all covered. Second consideration is that the R&D strategy masking. This is very important, that what the information we want to mask from the public, we do not want to disclose. India is a very small players market. A lot of small players are there rather than big players. So possibility of leakage of the intellectual capital is very high here with the turnover of people and collaborative networks. So it's very interesting thing that what we should publish. Means, I mean to say, publish means if you make a patent, it will be published after a certain time. Now, whether if we file, whether we will allow our competitors to follow that, or we will just keep it as a trade secret kind of thing. That is a very tactical consideration. One more thing is that patent versus publication. This is a very crucial thing in the premier R&Ds. Premier R&Ds generally most of the R&Ds do not go for publications, open publications, but premier R&Ds who has a collaborative network with the CSIR or other labs or these top universities, they always try to make publications. Even I have heard scientists, at that time I was in Dr. Reddy's, so I heard one scientist one day saying, and that अरे इसमें अगर पेटेंट नहीं मिलता है तो अच्छा होगा, मुझे पब्लिकेशन मिल जाएगा. Means he wants that compound not to be active so that he can file, he can just go for a publication rather than a patent. Because for a scientist, core scientist, value of publication is more rather than, I am talking about the academic value. That's what this conflict of academia versus industry comes up very much. It's a very crucial consideration that what we will publish. Mostly we publish the data that are not patentable business-wise. Means the compounds which are not so active, those are published. But again, tomorrow that particular compound might be active for some other purpose, some other therapy. So that crucial consideration one R&D has to decide accordingly. One more very important point that we have come across in my practical life is the litigation. Drug industry when is all about US market, and US market means generic market, ANDA. ANDA means litigation. So now today we are working towards some ANDA project that will end up into litigation most probably. Now, if we today file a patent, that disclosure should never go against the arguments we will be making in the litigations. It's a very serious consideration. We may lose very badly the litigation cases if the patent disclosures are in the just opposite direction. I had very bad experience about it. And as in previous session, Rohan said that the business dynamics, every 2 years, 3 years, technology are changing. So whether it is worth to file, whether it is worth to invest the money behind it or not. Christian said no, that we are filing mostly PCT route and not directly to European route. The reason is that we are unsure whether we will go ahead with that work or not, that project or not. So first, at this moment, let us file PCT. After 2.5 years, we will take the decision. That kind of postponement comes into the mind. So these are the practical considerations. There is no hard and fast rule that one has to be patented or not. But these are the practical considerations that are made in the R&D houses. So anything to add?
So think of the dilemmas, basically elaborating on them. So now looking at the practicality. So from morning we saw there are a lot of tools that are being utilized. Everyone talked about tools, IT software systems, AI. So from you within the system, do you have a checklist or do you have a strategy that you look at every time you go up and take a decision? So I'm interested in looking at, is there a way that I can get an insight on how do you decide, and is there a checklist that you have?
So let me share our experience. So like in 2012, we were around 414 patents application filed across all the geographies. This was around April 2012. Today we have almost 5,000 patents filed across other jurisdictions. In 2012, we have say 2-digit granted patents. Today we have almost 1,000 plus granted patents. Now what happened is, during the journey of last say 8 years, we faced two challenges in the beginning, that we had to convince our inventors or a scientist community that you should focus more on filing patents rather than publishing a research paper. And in order to change their mindsets, we really need to make them aware about the patent analytics. And I got into PatSeer. We had a demo for all of them, and then we ensured them that this is also a publication for you, which gives you international recognition, which is equally or rather more important than what research paper gives you. Now the problem in the Indian system is, every inventor wants to have some sort of reward, recognition and benefit being an inventor. So we started some reward system in our organization, wherein inventor who comes up with a new invention disclosure will get rewarded with something. Once the patent application gets filed, there comes one more appreciation or one more reward. And if the patent gets granted, there is one more reward and recognition. So it's a kind of, incremental motivation to inventors to come up with a new idea and file maximum patents. Now coming back to your specific question, we have encouraged them to file patents. So we filed so many patents during 2012 to 2016. Enormous amount of patents. And then suddenly we realized that now we are getting examination reports from various jurisdictions. And then we have realized that many of the inventions were probably not hitting the patentability or patent eligibility. And then we have decided to have gates. We prepared a checklist and a questionnaire wherein we give emphasis on two most important aspects. That before even submitting your invention disclosure, these are the questions which you need to answer. Questionnaire for patent eligibility, and we have designed that patent eligibility questionnaire in terms of the provisions of the various patent laws. And the second one is patentability. That is our internal IP team which decides whether this invention which is submitted by an inventor is really patentable or not. And that's how we could control to take up only those inventions which we can anticipate that, okay, it will be good to have this kind of invention to be able to survive, sustain during the stage of examination. So this is what is our strategy.
Very
generally-
rightly said, Nilesh. I mean, you being part of TCS, which is purely a software firm, of course, I can understand the opposition and filing examination from Section 3K especially. Yeah.
Indian patent system has not yet, so thankfully Indian patent system has not yet started giving us examination reports. So we'll see what we...
Yes, that is also an issue, So when you file a patent, and in my earlier organization, I received a grant of a patent after almost 8 years. I filed in 2000, around say, let's say 2009 or so, and after almost 8 years, I got a grant. What is the life remaining? And what is the actual business benefit of that particular invention? That was a real bothering for me as well as my management. Thankfully, of course, nowadays, Indian Patent Office is coming up with so many new recruitments of examiners and usage of so many tools and techniques, so they are taking less time. But however, unfortunately, lack of availability of utility models, which is a very quick filing and getting a grant and specific limited life of 10 years. Unfortunately, it's not there in India. So there are some concerns from office point of view. There are some, since you've asked about what internal decision-making things, I would like to also, from R&D point already, Nilesh has given a good experience, a good exposure, how systematic way is there. I would like to draw some attention from the business, marketing, and the other aspects. So yeah, whenever an invention is received, technicalities, yes, no, patentabilities, yes, no, all is done, but the business relevance, how much money I'm going to get it out of it, really. That is something, as an IP expert, you have to consult the relevant business. Whether it's a really new product, whether that particular invention, technology or product related invention, is it really relevant to my product portfolio or something different? Should I really put investment in that particular technology or not? And when you answer all these questions related to the marketing, related to the business relevance, monetary things, that is when you actually come to a conclusion whether or not to patent it. Sometimes, so in my current and previous organization, we also have a big R&D and the test setups. So they also do some inventions which are related to some different innovative test methods. I would like to ask you guys, if you are an in-house IP counsel or an IP expert, if one of the inventor comes to you, says, okay, let's say you're a mixture manufacturer. You also have the R&D for that, and one of the inventors says and comes and say, hey, I have some invention which is testing the noise in the mixture with a very less time, running time. What will you say, whether to patent or not, and why? To an audience, please. Just an example, or what is your thoughts on that?
Yes, because when we are using some mixture, it will be certainly being made by somebody.
Yeah?
So why, if at all, it's got some positive feature, which
That is not at all a feature of a mixture. That is a testing method to test the noise in the mixture.
Okay, testing method. Does it not add value to that testing method? And there is a scope for out-licensing. May not be usable in-house for that particular business setup. However, it needs to be evaluated. Not that you should go for patent right away, no. Needs to be evaluated whether it has got some value as a patent, as a product, which can be out-licensed and maybe of interest to parties who are having interest in this kind of a business.
Very good positive on out-licensing. From India point of view, I will say something else. If I am your competitor, you have published filed a patent, published it, public domain mein aa gaya, I have checked it, I have prepared it, and I have secretly made such test system in my R&D somewhere in some corner room. How you are going to identify whether actually I am infringing your IP rights or not?
Only when you make mixer which make low noise.
Madhav, when you make mixture with low noise, fine, but how you are going to know your competitor has actually taken that idea and using it in his R&D center? It will be very difficult, believe me.
It would.
Do you really think that happens? Yeah. It very rarely
It would be
happens.
really hard. It would be really hard to get that.
Yes.
I am talking in respect of starting off and take off stage.
But when you talk to your business, do you really think they will understand all this? No, it is very difficult. So such kind of things, it is very much to keep trade secret, or sometimes, not to patent it. Because as a patent expert, you think about out-licensing, but reality, somewhere someone using it in some secret R&D room, you will never know. Your worker forget it. Workers are not allowed in the R&Ds.
Garg, I disagree with your this statement.
Yeah.
This may be the case with the companies having very low portfolio as far as patent and invention is concerned. But as far as my experience goes, the company always in alignment, be it R&D, be it IP team, be it business people, everyone when jointly take a decision about anything, there is a called as IP segment committee
Yes.
or business committee team or R&D
Yes.
setup team. Always there is a decision to go for patent, what is the pros and what is the cons, as well as a cost analysis is made, strength of invention is calculated, and then, so I
Exactly.
differ with your statement
I
that
totally-
business will not accept. Yes, they definitely, when you have proper IP analysis, if you throw them, what
Exactly.
is the benefit of trade secret and what is the benefit of
That's where I'm coming. That's where I'm coming. So it is not only the IP team or the R&D team, the business team, marketing team. Nothing to relate with much larger portfolio or a smaller portfolio. It is how much cross involvement of teams is there. That is when the decision making will be more strengthening. So yes, it is not only the role of IP, this is not only the role of R&D, but also involvement of cross business teams to finalize on such critical inventions. Of course, day to day, we are not facing such. But when such critical inventions are coming, it is important that cross teams jointly have a discussion, held a discussion, and come out with something else. Thank you.
You also check whether there is a policing system, as in if it is a process invention or it is like a technology
Method
which
or a
is not
system patent,
easily
yeah.
mapped, then always we analyze whether we have tools to police that in that particular invention if somebody copies or infringe. If the answer is yes from the scientist and the business, yes, we go ahead with the filing a patent application,
That is-
provided it qualify the criteria of patentability.
That is all good when you say broadly with good companies and big large firms. But when you say some kind of test methods, although it is qualified for the patenting, someone, when you patent, someone is copying and secretly doing in some warehouse or somewhere, you even never going to know where it is going to be, used. It is very difficult. So you have to be very calculative. Nothing about your high portfolio, low portfolio, or how big is your R&D or how many number of patents, nothing to do with that. It is always how good decision making is done with the multiple cross-functional team. That is more important. Yeah.
Draft a patent application.
Exactly.
Wouldn't
Agree.
you rather draft a patent application and lot of specifics you do not have to disclose in the patent
Agree.
application,
Yeah,
right?
that is
And
one of the
have
way.
it as a benchmark. If it becomes an industry standard tomorrow because it is a useful invention, wouldn't you then want to leverage it in license? And if say just a public domain document, it would be very difficult for a competitor to make it exactly like you have done. And just specific to this example of yours.
Agree. So that is one aspect where I will less disclose the actual, novelty, but will be, of course, little difficult at the examination stage. Secondly, even if you disclose some aspects, it is easy for the competitors or the experts who are, know how about the invention to exactly, replicate the things. Coming to the, licensing, how many patent licensing in India you are seeing, my friend?
Yeah, I would like to answer you this question.
Yeah.
Instead of not patenting, with this kind of a scare, if at all somebody is using, we will not come to know.
Yes.
But my point is, if you are not if you are not making a patent, you are making it rather, you are inviting to be free without any scare to use it.
Why?
Of
How
course,
come?
because
What is
you
the
don't-
what is the
you-
trade
because-
secret then?
Because when your trade secret is there, these are the things depends upon the extent of secrecy
Yes.
and
Yes.
extent of difficulty in copying it.
Yes.
If at all extent of difficulty copying is really something very, very difficult,
Yes.
then I agree with you.
Yes.
Otherwise, I disagree with you in the sense, disclose in the public domain,
Yes.
you have got a proprietary right.
You have
which will
Coca-Cola and many
rather-
examples which are
rather-
successful.
That's a trademark. That's a trademark. Let's not
Coca-Cola
combine
is a
apple
trade
with the
secret.
banana.
Coca-Cola is a trade
No,
secret,
let us
of
not
course.
combine apple with banana. Let us keep apple, banana, bananas.
Yeah. So,
Patent and trademark is a
so
different
it is
things.
up to your company. It is up to your company how much expertise they have in keeping the trade secret. But yes, calculatively, not two or two patent. It is the decision which multiple aspects cannot be independently taken by the patent team.
Summarize your point is very right that it's not easy
if it is not easy to prove the evidence of use, then
Yeah.
it could qualify for a trade secret, because if it's going to be very difficult for somebody to independently research an evidence of use for that type of innovation,
Yes.
then you might as well keep it as a trade secret.
Exactly.
I think that was to
That is
summarize your
summarized.
point.
Yeah,
yes.
yeah, perfect.
I have a tangential, slightly notorious question related to this.
Yeah, please.
In-house IP members and R&D people, how confident they are that when the R&D employee who knows about this switches to another company, he will not disclose it. So it's something external to the in-house fraternity.
Yes,
I'm
Nilesh.
asking this.
You might be aware this terminology, willful infringement and non-willful infringement, right? In the court of law, you need to prove that you are not a willful infringer. That means you were aware of the consequences. However, it has happened by mistake or by unintentional way. However, it has not hampered any third party's market business or something like that. So when you really need to prove that you are a non-willful infringer, you need to have certain setup in your organization. You need to have certain agreements and declaration from the inventors and scientists community at 2 stages. First stage is when you are recruiting. Having a signed declaration that during last 12 months or 24 months, whatsoever inventions or confidential information they got exposed to their previous organization, they are not going to replicate, duplicate, implement same in my organization. That is first thing. Second thing is, I as a team leader from my project, if I want to avoid them being a potential IP contaminant of my IP team, I need to have that declaration in place in order to avoid future consequences of willful infringement, right? And the third stage is when an employee resigned from your organization and departing. So there we need to get him sign the declaration and agreement wherein he is assuring not to disclose the confidential information and the proprietary information to third party. So these are all measures you can take, but you cannot control whatever is he's taking inside his brain, but at least these measures you can take to be compliant. That's what I feel.
Ajay, one thing I'll just tell you, see, this is 10 years ago concept that वो किसी ने मेरा सामान लेके भाग जाएगा तो उसके लिए I will file a patent. Today's date, big companies do not think in that manner at all. They think everything from business perspective. If there is a business at all, then only go for a patent. Otherwise not, because tomorrow or day after tomorrow there is no assurance that we will be practicing the same patented invention again. I am giving you an example. We made a process patent that was in early 2000. Then in around 2005, 2008, we came up with the second process and we changed the commercial process. We have another patent. After 3-4 years, because the inventors left, क्या हो रहा है? Inventors left and new people are coming. They want to show up their business. They want to file their, this appraisal reports. So we file kar do sir. So then after 3 years, again the process changed, and there is no more room to file a new patent. What happened? Today, the commercial process is actually not patented. So whatever money you have invested behind the initial 2 cases is completely in water. So this is a very serious consideration to the companies. Company will not go after a particular fellow, and that business aspect stands very well in case of startups, as you mentioned. For a startup, if I have a startup today and go to some big person, that sir, मेरे पास एक invention है, आप इसको लेके file कर दो licensing करके. Nobody is going to listen until and unless there is a specific market for that product. So first, come out with the market. Determine whether your market is domestic or US or Europe or Africa or China or whatever it is. Accordingly, you should approach the person. Yes, this person is specialized in Russia market. Let us approach him. तो थोड़ा कुछ हो सकता है. Otherwise, nobody is going to listen.
So before you ask a question, just to answer your query, usually companies now do have a policy wherein they will sign in a contract wherein you cannot join a direct competitor. So for example, my company Ethicals is a topical. So all the R&D employees, including the legal and IP team, have been barred from joining any direct competitor which do only primary business of topicals. So that is to ensure that you don't pass on information for the period of 3 years. By that time, if there is something to be done on an IP front, the IP has already been filed and protected. If it is a trade secret also, some leverage is also done in the agreement that if we could locate that you have disclosed something which was a proprietary information of a company, even after 3 years, we can bring a suit on you. There are also companies that during interview you need to disclose whether you have such kind of obligations. And if you say yes, they will simply end the interview saying thank you.
Okay. So I agree with you, the point, that you have to be focused and relevant, with respect to the company business. Now you imagine like you have to drive innovation in your company, okay? And you are talking about come up with innovative idea, come up with innovative idea. And then people are coming with you the innovative idea, and then people are nowadays intelligent also. They understand, yes, this can be patentable. And if you are turning them back, now you imagine the power of word of mouth. So how do you balance this? Because at a time you want to drive innovation in your company, but at the same time,
this is a good question to keep people energized, to give them incentives. Right, so most of the things it is done means we can file provisional application Indian. It doesn't cost much. Then at the and then at the max, and then keep it watching for 12 months, progressing or not. But this is the real consideration. And then maybe after 12 months that person has left the organization.
But why we are thinking that the person will definitely leave the organization? I mean, I am not understanding that.
Sorry to interrupt and answer. Basically, the process that we usually do is whenever we get such kind of information or a query that I believe this is a patentable invention, and we conduct our IP search and come up with the point that, we feel that it is not patentable, the best way is to involve that person in a discussion and try and understand why he feels it is patentable and convince him why, based on the IP laws, based on the case laws, based on whatever information you have in hand with facts, why you feel that it is not patentable. And most of the time, we have seen that a person who initially thinks that, it is patentable, will understand actually that it was incremental invention or it was not really a patentable invention because he had missed something. Maybe some point of law which he missed, or it could be some prior art that he overlooked or he missed.
So one more thing I have done actually, in this type of minor improvements, you can lead that particular scientist. That's what I believe in, and we have done couple of cases. That once they come up with an invention, how to really increase the periphery of that invention. And you can really go for a broader umbrella, and sometimes we get very good results from the R&D scientists. So that is the intellectual capital worth of an IP guy to give proper direction to the R&D scientist. You add up something, itna se nahi hoga, you add up, and these are the perfect areas you can probably work out. You may generate some new patents.
So we are short of time, and I think we need to wrap up. So we're going to be outside. If anyone wants to discuss this further, we can definitely take it and maybe have a detailed discussion on what should be the strategy. And because this is a very interesting topic, we're going to start